Shai. Supreme Court Justice, His Honor ניל הנדל, is honoring us this evening. I believe that Justice Handel expresses a new spirit that prevails today in the Supreme Court, a spirit that reflects a greater degree of readiness to consult Jewish law. This year, for the first time in our faculty, we held a workshop that deals with the use of משפט עברי in the Israeli courts. And one of the most fascinating sessions was the session with Justice Handel. We read a number of his rulings and analyzed them together with him in class, how he had utilized משפט עברי in the rulings. If I'm not mistaken, in the history of the Supreme Court of Israel, there is only one judge that trained in the United States and also uses משפט עברי in his decisions. Justice Handel is deeply rooted in both Jewish and Western culture. His rulings reflect a deep commitment to both cultures, not to evade the tension between them, and to aim for a correct way to balance them. In spite of his very busy schedule, Justice Handel is always ready and happy to cooperate, and we are very grateful to him for that. I'm pleased to invite the Justice Handel to share with us on the episode.
Thank you and good evening. It's a pleasure to be here. I've been following the Jewish Law Association's publications for a very long period of time. Before I was on the Supreme Court, before I was a judge, and the work that you do is very, very important. To explain how the court looks at things, I'll quote a story about a famous scientist, I believe it was Carl Sagan, that he was asked, do you believe in God? And he said, I'll answer the question, but you're not going to understand my answer. Do you want me to answer the question anyway? And the questioner said, yes, answer the question, do you believe in God? And his answer was, yes. And in a similar way, I would say, if you ask the question, do I believe in Jewish law and its connection to Israeli law, it's not obvious, or you may not understand my answer, but the answer is yes, in a similar way. And it's very difficult to apply a different legal system that spans countries and decades and centuries to a modern legal system. It's not something that one could take for granted. And one could easily say that it should not be applied. However, I feel this would be incorrect for many reasons. Before I go into the reasons having to do with Jewish law, I'll say that in general, I think that one of the fascinating aspects of law, especially secular law, is that there really is no right answer. There are questions that come up in different times, in different countries, different answers are given, and it's not really a question of right and wrong. And so therefore, and this is the general view of the Israeli Supreme Court, there is a recognition of the importance of comparative law. That is to say that unlike the American Supreme Court, where there was a dispute between Judge Kennedy, who was for the Supreme Court, for the use of comparative law, and Judge Scalia, may he rest in peace, was against it. That is not the case in Israel. Also, I believe it's very natural for me to be here because there is a close connection between the faculty, the academic world, and the court. I mentioned as an example of this Justice Kagan from the Supreme Court, who came to Israel and met with us, and I said to her, why don't you use academic writings more? You're an academic. And she said, whoa, slow down a little bit. And then we sat and talked about it. And the culture in America is different in that sense. Here, it's quite natural. And many of the people here, friends and I would say people that I enjoy discussing issues with, because it impacts on how you look at the problem. That is to say, because I don't think there's a right answer in law, I also think that comparative law can be very, very helpful to how you frame the question, how you frame the answer. It's you, as a judge, what you want to do is you want to do the just thing, you want to get it right. It sounds simple, but it isn't. And so what you have to do really is be open to different approaches. Now, when we come to Jewish law, that's an entirely different question, because Israel, first of all, historically has a special connection that it does with Jewish law. And secondly, now in the human law, human law and dignity, which is viewed as a basic law, which is viewed as a basis for allowing the Supreme Court to declare a law unconstitutional, states that Israel is a Jewish democratic state. That's the phrase that's used, which implies what does it mean that it's Jewish. I don't view Jewish in this sense as something ethnic. One of the interesting questions or issues about Judaism is how much it's involved with law. There's a famous story during the Holocaust that there was a famous judge from Hungary, a non-Jewish judge, that was on a train with a rabbi who was running with students to escape the Nazis, and they were all sitting there, and he said, "What are you? You're a rabbi. What do you teach?" He said, "I teach Talmud." He said, "Yes, I've heard of this. What do you study?" And he said, "We study issues like tort law and contract law and all these kinds of things." And he said, "You're not all these little boys that are 10, 12 years old, they're really already in law school? It doesn't make sense." But there's a lot of truth to that kind of view. And so there's a vast amount of material in Jewish law which can be utilized and should be utilized. Now, I want to make this more concrete, so I'll just give a few very brief examples. One example is where it can be useful. There was a case not long ago in the Supreme Court where there was a dispute in the following question. I'm going to say these things very, very quickly, just so I can give you a flavor of a few examples. The question was that there were there was a drag race, that is to say there was a motorcycle, there were two cars that were in a race, and they both were trying to go as fast as they can, so, to win the race. And one car flipped over. The car that flipped over wasn't at all impacted by the other car. It wasn't that the first car went to the second car, but the second car flipped over. And as the second car flipped over, what happened was the state was of the opinion that you could prosecute the driver in the car that survived for causing the death of the second driver. And this question came up. The case was heard twice by the Supreme Court. In the first session, I was in the minority opinion. I thought that it's not appropriate to accuse him or to find him guilty of murder. In the second case, on the second round, where there were more judges added, a fuller panel, the result was that while he committed a crime, he did not create the crime of causing death. Now, I mention this example because sitting with us is Michael Vigoda. I'm sorry, I said your name in English for a second. Michael Vigoda, who works with is actually in charge of the Jewish law part of the Justice Department. And what's fascinating is that even though he works, so to speak, with the prosecution, the defense counsel turned to him and said, "What do you have to say about this case?" Now, unlike most lawyers, he did not try to hide that, in his opinion, the prosecution was not correct in their evaluation. And he gave a very, very interesting example based on a Talmudic passage, which is the case where someone puts burning coal on the chest of another person, and that person dies, is the first person responsible for the second person's death. And the view is that he's not, and the reason he's not is because of the fact that the second person had the autonomy to choose not to stay in that position, or as his hands were untied. And given that, that sort of cut off the causation question between the act of the first person and the result that happened to the second person. This was obviously very, very relevant to the question of causation in the case that I mentioned, that is to say that the second person, the driver who died, made autonomous choices to be part of of the race, and therefore he should not be found. This is one example. There are many other examples. Since we're in Tel Aviv, I'll refer to two aspects here. I'll refer to Professor Dre that wrote a great deal about the law of conversion and the connection between the law of conversion and the right to return, and should it be limited just to the rabbinic court. Recently, in a case, we decided it should not be limited to the rabbinic court. I see Professor Wosner has returned. He mentioned that his writings on Rabbi Shimon Shkop in a book that just came out have also been very influential and very, very important. Shimon Shkop is a very interesting example. He's written on issues as diverse as the power of confessions, and in a case which I'll bring up in a few seconds, which I just gave recently, I'll talk about that. I mentioned it because they're good examples, because in what Professor Dre wrote about was very, very relevant, and what you write about at first blush seems very, very irrelevant in the sense of talking about a rabbi. It's very relevant in a practical sense. It might be interesting historically, but what I find, and I say this to all of you, one of the words I most dislike is the word relevant, or put it another way, I think relevant is a very irrelevant concept, and I find that writings on all sorts of issues, be it historic, be it a particular time, turn out to be in the end very, very important and very, very useful to the court. I'll give just one example. We're talking here about technology and science, and you want to hear a lecture about copyright law. Just a few weeks ago, I gave a decision on, wrote a decision which was approved by the other judges involving patent law. It had to do with Merck and a competition between different countries, America, Germany, and Israel, how we should compute the patent law. So in this question, which was important enough that the Attorney General asked to be part of the case, I wrote a lot about Jewish law, and I found it quite fascinating. First of all, the whole question of what does it mean? What is a patent? Where does it come from? And Rabbi Shimon Shkop, which you just mentioned, talked about the fact that in the time of the Talmud, they mentioned 4 prototypes of damages, one of them being the pit. And Rav Shimon Shkop discusses the question: why are you responsible for the pit? That is to say, if you have a pit in which you, in your own hands, developed in the public sphere, you're responsible. But and he goes into a whole thing because it's something you created, and it's a principle that something that you yourself create, you have some sort of property rights to it. This he further developed in a different response by saying that just like if your hands create something that belongs to you, so if your mind creates something, the mind is also part of the individual, it also becomes a property right. I quoted also Rav Herzog, who wrote similarly about this issue, and a modern-day sicer of Jewish law, Rav Asher Weiss, who talked about the fact that this must be recognized because it's part of what the individual does. That's on the one hand. On the other hand, we talked before that we wish to show what can be unique about Jewish law. So the issue involved a question of a certain drug that could help many people. And on one hand, there is a property right. On the other hand, there is a recognition that there is an obligation. Here you see an interesting tension in Jewish law. On the one hand, it recognizes property rights, respects property rights. On the other hand, it also recognizes social responsibility. I brought a Talmudic passage which talks about Rav Yochanan, where what happened was that he sort of tricked someone. It's a story, like many stories in Talmud, that has a lot of what they say in Hebrew, a lot of chayim to it, a lot of grace to it, in which he asks someone for a drug, and the person says, gives him the drug, he says, also for tomorrow. He said, what about on Shabbat? You won't need the drug on Shabbat, says the one who did the drug. I don't want to reveal it. He said, what if I have a very big need for it? What are you going to do? He said, okay, I'll give it to you, but you have to promise me that you won't tell anybody. After a few days, after Shabbos, he then told everyone what the drug, what was in the drug. And he discussed the reason why he felt he had to do that was because of the fact that at a certain point it also belonged to the public. So you see this is a very interesting example as the tension between, on the one hand, recognizing the property right, and the second hand, the social responsibility that goes with it. There are a lot of other examples. I'll just mention, since he recently passed away, Professor Kirschenbaum, who was mentioned before, wrote extensively about the right against self-incrimination. I used a lot of his writings in cases that helped develop the Supreme Court's view on it. And as I say, despite my fondness for Jewish law, if it doesn't come through, it doesn't come through. And surprisingly, it has very, very real insight, dealt with issues in a very real way. And it's been very helpful. A lot of the issues in the Supreme Court that come up are real. You have to understand that in Israel, I know you just had a discussion about taking sperm from someone who died after he died and so forth. This, first of all, to me sounds fantastic, but not only is it not fantastic, there have been cases in the Supreme Court over this very, very issue. And of course, when you come to this kind of question of morality, technology, and medicine, Jewish law can be very, very important. So what I'm trying to say is that you should appreciate that what you do is, even though scholars sort of sometimes like to be in their own place, and I envy you sometimes that I have to deal with people and problems and resolutions, and something has to be decided, and it's very, very important. I like to give the example with abortion that, on a theoretical level, one could argue 1,000 years, what is a fetus? Is it a person? Is it a semi-person? Is it a half-person? Is it not a person? But in the rule of law, if you don't decide this decision within 9 months, then the decision is made. So there's that tremendous gap, and it's very, very important, and it's very, very helpful that this is done. There's also, I see Professor Kleiman here, there's also the aspects that there are rabbinic courts, and what's the relationship between the rabbinic court and the secular law and Israeli law, which he's written about. And I can go on and on with other people here. I won't include everyone, but I just want to say that it's very important. I'll just finish with what the talk is about, or the topic is technology, science and knowledge on Jewish law and ethics. The question was raised, does Judaism have a unique view about it? And I would say that anyone who's read Rabbi Soloveitchik's writing in The Lonely Man of Faith, where he talks about the two stories of creation, in Genesis, Adam 1 and Adam 2, and Adam 1 talks about the fact that Adam 2 is a figure that retreats more. Adam 2 is a person who's more alone. Adam 1 is someone who follows the dictate of Genesis, which is that you should fill the earth and capture it. And capture it, according to Rabbi Soloveitchik, means that the scientific the impulse to understand knowledge, to gain control of it, is something that's very important. He also writes there, it was interesting, he wrote about in the 60s, he wrote there that someone that can go from Boston to Israel in 7 hours has a much more dignified existence if he can fight disease, if the roads are different, than someone who does not have this. So he tied it with the very modern concept of human dignity. That's one of the blessings that science can give. And the dangers of science are also there, but it's important to recognize it. In summary, again, I want to wish you all a very successful conference. I looked at the different topics. I'm sorry I won't be able to be at more of them. I may harass some of you and ask for the paper in full, because there's various parts of it. A lot of the things interest me. In fact, it's all interesting. But just to be aware of the fact that, in general, these writings are important in themselves, and in Israel they have great, great practical effect. Thank you.